it comes to elected members, that is what we now look at the law. And even if you cross carpet, that does not make you to lose your seat automatically, because it is the Senate President or the Speaker House of Rep of Assembly that will give effect to that section 109 subsection 1 paragraph G.
Yep.
In the case where the Speaker, the Senate President, did not give effect to it, it remains like that. So we cannot tell politicians that for us to impute or to inculcate morality, integrity to our political scene, we should maintain some level of integrity by staying put with our parties and following what the law recommends. This is what I'm saying. So, rascality and impunity is when somebody now assumes the position of the law and the court, and began to dish out what the court ought to have done, usurping the powers of the court.
All right, very well. Nze, you want to respond to Amy's statement?
You know, one thing first, we must bear in mind, this society belongs to us, and we must set records straight. If truly everybody's interest is the general well-being of the populace of Rivers State, that's where you begin to see that some of our assertions, or if I may say assertions, and the view over all this brouhaha will be affected. Because if my response to what is happening in Rivers State is born out of my interest for a sane society, if this is truly what I want, I should be speaking from my angle. Like, look at the judgment of Supreme Court. I told you that the court has spoken. Yeah. And there is nothing we can go and do about it. Court has spoken. If all of us collectively come to say, we will establish a magistrate court, we will establish a high court, we will establish an appeal court, we will establish a Supreme Court. This is a product of we. These things, these institutions did not create themselves. We created them. And we said that they will guide us like this and they will guide us like this. We came together to say, this rule, without looking at anybody's face. That is why you see that law will always have its eye blinded. This rule will guide us. This rule will guide us, just as Amy said, that the court, the constitution is there to guide our actions. And these things are set clear before us. Coming from the angle that we are looking at now, Supreme Court has given judgment on the case that was brought to it. Because just as we know, I'm not a lawyer, but we know that the court will not respond to any prayer you didn't present to it.
What was the prayer that was presented?
No, I'm coming. You're looking at what Supreme Court is handling. They have declared their own judgment on it. And the Rivers State government have come to say, we acknowledge the judgment of the court. We will study the CTC of the judgment, and we will look at the implications and respond adequately. That is okay. But look at where I'm looking at from my viewpoint, that it is happening in Rivers State today, and the Supreme Court has come to give this judgment. I am a Nigerian, a true certified Nigerian, and I have lived my life as a Nigerian, and I will defend the interest of Nigeria and the well-being of Nigeria. If by tomorrow another thing happens, either in Lagos State, either in Kaduna State, either in Oyo State, what Supreme Court, the precedents they have set now, should be upheld. And what are those precedents? That somebody whom the High Court has given judgment should obey the judgment before appealing it. If it happens again, though I'm not a lawyer and I may not go to court to defend, but I think I may have right to sue, even though I'm not a lawyer, and lawyers will go there and interpret it, using what Supreme Court has done.
You recall what we've had this conversation before?
Over and over.
And I told you categorically, I told you, Claire, and every other person, I said, appealing a judgment does not translate to stay of execution. They are two different things. A judgment can come and you're not satisfactory with that, you're not satisfied with that judgment, sorry. you can choose to appeal that judgment. But in appealing that judgment, you will have to obey the existing one. However, if you feel that obeying this existing one will be injurious to you, you apply for stay. And stay of execution is not automatic. You apply for it. And when you apply for it, it is at the discretion of the court to either grant it or not grant it. Right? So it becomes interesting because, I mean, Nigerian politics and the lawyers that they have employed so far, you know, to a large extent, it is what it is. But then, in Rivers State, it became interesting that when it comes to politics, the law is given a different, and in Nigeria, the law has to be followed to the letter.
But do you know that it's supposed not to be like that?
To the extent, let me give you an instance, a common instance. If you are my landlord, I'm your tenant, and probably you give me quick notice that I feel the processes that you have followed, you know, it's not right, and I decide to take that matter to court, or I refuse to pack out, or let me use another one. I refuse to pack out after you have followed due process. You've given me quick notice following the legally laid down process, and I refuse to pack out. And you're not wanting to resort to, you know, taking laws into your hands and all of that. Might decide to take this matter to court, right? And the court might give judgments or gives judgment and asks me to pack out within a specified time. And I run to the higher court to appeal that judgment. I appealed it. It will be before the court, but I will pack out. Unless I apply for ex parte order, stalling that, or I apply for stay of execution. The court may look at it and find out that if this stay of execution is not granted, it will be injurious to me. They may decide to grant that stay of execution. It means that I will not pack out until the appeal court hears that matter, or the higher court hears that matter.
But is this not how it's supposed to be in every strata of
But
our
you
life?
have made a case over time, Nze, on this show that the governor has appealed the matter, and because the governor has appealed the matter, the governor can go ahead to obey the law.
Now let us look at it from this angle.
Yes.
You just painted a picture which is very, very clear. I'm a Nigerian, and this system runs through me too. If I have any matter, the same proceedings will take its course, isn't it? Now, in the case, are you getting me? Now, it is their duty to go to court. It is their duty to carry out these functions. When a judgment is given, it is their duty, if they look at it, if they look at the fact that it is required that they get a stay of execution, they should apply for it. And before appealing, or after appealing, whichever way.
Can I give you an instance of a stay of execution that was actually applied and denied in Rivers State matter?
Yes, I know.
I should give you an instance.
I know about that.
So does doesn't that concretize the fact
but the
that
reason,
stay
the question
of
we now have to
execution
ask,
actually does exist?
yes, it exists. Now, who does not know?
Right.
But the question I want to ask, why should a lawyer or why should a judge deny a citizen stay of execution?
It's discretionary. Nze.
Can we be educated? Can we be educated on the merits?
Let me give you an instance.
Can we be educated on the merit of stay of execution?
The question you just asked is akin to asking, why have I presented prayers before the court, and the prayers and the court, after looking and investigating after trial, decided not to grant my prayers?
No, I think that should be different from this.
No, it's the same, because God has said, and then awaits the judgment of a higher court.
See, there is something we are looking at here.
Yes, go ahead.
And we are looking at creating or building a sane society. That is first and foremost my interest. Creating a sane society, creating a balanced society, where nobody, no matter how highly placed, will use his position, as much as I am subjected to the constitution of this country,
Should I remind you of what the Federal High Court said before it adjourned its sitting to April 30?
I think that was clear.
Hold on. With regards to the issue of defection, Okojombo led faction, or I don't think I'll call them a faction because Supreme Court has come out. Okojombo and his friends, that took that matter to court. The Federal High Court sitting in Port Harcourt adjourned that matter to April 30, and the judge said that matter will be adjourned pending when Supreme Court gives judgment. So now this matter in Federal High Court is predicated heavily on the outcome of the Supreme Court judgment. This is the implication of the statement of that judge. A lower court, because when the judge was speaking, the judge says that he cannot entertain a matter that is already before the Supreme Court. That's the statement of that judge, that he cannot entertain a matter or give judgment on a matter that is already before the Supreme Court. So that this court will be adjourned pending when Supreme Court gives judgment. What is the implication of that statement by that judge? If Supreme Court has come out to give judgment, are you expecting a high court, emphasis on a high court, to counter the Supreme Court?
No. Do you know that when this judge...
High courts will give judgment based on locus classicus in this instance.
No, we can't preempt what the court will come out with.
It is what it is. I need you to understand that this is the statement of the judge when he was...
We all saw it.
When he adjourned that matter.
We all
so
had
now,
that statement.
if the Supreme Court has come out clearly, unequivocally, to say that Martin Samehule is the authentic speaker of Rivers State House of Assembly, and that the assembly should... It's not a declarative statement. It's not declarative enough.
On the basis of the case before Supreme Court. On the basis
of the case before the Supreme Court. Now, let me bring you back to the Court of Justice Omotosho. Let me bring you back to the judgment of Justice Omotosho. The judgment of Justice Omotosho also affirmed Martin Samehule. Now, the Rivers State government went and withdrew that appeal at Supreme Court. Do not forget that the lifetime of the judgment of Justice Omotosho handled both the pre-defection, supposedly pre-defection, and post-defection. That matter was instituted 29th of November. The 27 lawmakers allegedly defected on the 11th of December. In fact, that matter was instituted 11th of November 2023. The 27 lawmakers allegedly defected 11th of December 2023. And judgment came 22nd of January 2024. Now, the Rivers State government had withdrawn their counter affidavit, where they had already, in pleading their case, talked about the defection. They withdrew it. Now, withdrawal of a matter means that you're waiving your rights to a case. And it means that you're agreeing to whatever is the outcome of that matter. And that matter was ruled against the governor.
Do you know that we
hold on. It is very important that you understand the implication of the dismissal of that matter by the Supreme Court. Now that this appeal had gone up onto the Supreme Court, it was withdrawn. And when Femi Falana was speaking, said it was because it is an academic exercise, and he based the withdrawal of that suit only on the 2024 budget. But that suit also had other prayers that were very important that it granted in the favor of the lawmakers and against his client, the governor. And the implication of withdrawing that suit or asking the court to dismiss that suit meant that if you married that together with this current Supreme Court judgment, how then are you saying that defection was not part of it? Was Justice Omotosho's matter pre-defection? because now lawyers are bandying pre-defection, post-defection, but the lifetime of that case handled all of that.
You see, when we look at this, that's why I told you that when we analyze issues from our viewpoint. What is preempting or what is permeating your notion or your view on a particular issue? Prior to the defection saga, this case had been instituted. And before judgment came, which happened in 2024 January, the governor has filed his counter affidavit. And in his counter affidavit, most of these matters were mentioned. Remember what you said, that when you withdraw your counter affidavit from a case that is instituted against you, that you have simply waived your right.
Exactly.
Now, the governor withdrew his counter affidavit in obedience to an advice.
Was it
which
during
emanated
the withdrawal? Was it quoted? Does the court even recognize that peace pact?
I'm
This
coming.
is the issue.
I am coming. If the lawyers of the governor failed in their presentation, I think we will blame the lawyers. But I know that the governor has been acting on the spirit of good conscience. When the peace pact was given, and he came back in order to obey Mr. President, he now withdrew that counter affidavit. And withdrawal of that counter affidavit gave Justice Omotosho the right to grant the prayers of the lawmakers, which by that time all of us came back here and shouted foul. We say that the way the president had given this order and this guy had come back home to implement, and at such point that Amoyule and his group refused to withdraw their own court case, rather continued it, that the carpet had been pulled off.
Can I ask
the feet of the government.
Can I ask you a question before I go over to Nze, to Emmy? When that withdrawal of counter affidavit was done at the court, did the council of the governor base their withdrawal on the ground of the peace pact?
That is what's supposed to have been
now,
done.
if it was not based on the ground of the peace pact, would you say that the peace pact was one of the evidences submitted in court? Is the court, hold on, is the judiciary even aware of that gentleman's agreement? It was not. So, what the argument is being projected now is not what the court is looking at. You're looking at emotions. The court is looking at the facts before it.
Yes.
And the facts before it.
Not really emotions, but moral.
But
we are looking at moral, not emotion.
I don't merge morality with politics in any way.
Yeah.
But then, Emmy, what do you have to say?
You see, this matter is not something we should overflow. You know why? Whether there was a peace pact or there was no peace pact, whether there is one moral man or there is no moral man, whether there is emotion or there is no emotion, or conscience, no conscience, the matter now is this. In say, my friend here, I assumably represent that interest of the Fubara and the rest of them, right? Whom they always say is a peace-loving man, which I will always disagree at anywhere. I even put out a word, even cause several. Let us have a debate. I will tell you, Sifobara, with all due respect, His Excellency, he's not a man of peace. I have never showed peace. That is me, and I will prove it 100%. People will be so amazed with what I will push out there. Now, the thing is, whatever withdrawal or no withdrawal, it doesn't matter here. He talked about something. That's why I say maybe represent that. He said, we should be looking at how we have a sane society. So for him now, our society might be insane. But I'm saying we are not insane. In pursuing a sane society, where a constitution reigns, what are the actions that is expected of a man, a person, or a group that is actually pursuing a sane society? Is it not to obey and follow the provision of the law? Now, if the law says ABCD is the speaker of Rivers Self Assembly, and as it stands today, there is no one law there is no court judgment, no court pronouncement that is subsisting that has said Martin Amiewule ceases to be the speaker and others cease to be members of the Federal Assembly. Is there any law like that? If there is none, a sane man was supposed to do what? Respect the law until otherwise is proven, isn't it? By virtue of court judgment or pronouncement, that now say, Martin, based on your action of ABCD, you are no longer the speaker. You are no longer member of Rivers State Assembly. It is only then that the same man was expected to say, former assembly member, former speaker. But you are saying you are pursuing a sane society. But I'm seeing a lot of insanity. Insanity in the sense that the court has not made pronouncement. The law that established the House of Assembly states how a speaker emerges and how a speaker is removed. You are disdainfully disregarding all of that. Even without court pronouncement, you have assumed that they are former, meaning you have removed them by yourself and not following the law. Is that sanity? Is that how we pursue sane society? By disrespecting the law? By disobeying the law? By imputing and establishing our interests at the detriment of the entire state? Is that how we pursue sane society? I expected that from Governor Sifubara, His Excellency, and every of his supporters and followers, they ought to have understood that the law that established that assembly have not removed Martin Amiewule. The courts that are product of the law have not made any pronouncement that say, Martin, honorable sir, you cease to be a speaker and your friends ceases to be members of Rivers State Assembly. But rather what we have all this while are pronouncements that says submit budget to assembly led by Martin Amiewule, resume sitting with immediate effect, submit all your business transaction or whatever you're going to do as a government, do all your business transaction with Martin Amiewule led assembly. What does that mean? It tells you that in the eyes of the law, Martins and his people are legitimate members of Rivers Assembly and they are the leadership of the house. And you are still saying that there is a matter in court. So by the reason of the matter in high court, you cannot recognize Martin Amiewule. And you are still saying they are former members of Rivers Assembly. Are we really pursuing the same society? Why don't you wait? Why don't you wait? Why don't you wait until the court or the law now prove otherwise before you now refer to these people as former? Before you now say they have ceased to be speaker and members of Rivers State Assembly. That is what a moral man, that is what a civilized man, that is why a conformed man who conform to laws of the land will behave by following the processes. But the court have not said otherwise, the law has not said otherwise, but by your own definition, they are now former. By your own conclusion, they are now former. You can't recognize them. It shows that you have no respect to the law, the grown law.
Let's set the record straight.
Go ahead.
There was something that was specifically mentioned here.
Go ahead.
When it comes to issue of the status of Amiewule as speaker and his friends as members of the house, we made it clear here that Supreme Court has spoken. And we stand by what we recognize the Supreme Court judgment. So when my friend Amy is now talking about declaring them or referring to them as former, what happened prior to the judgment of the Supreme Court has been overtaken by the judgment of the Supreme Court.
But you just said now, my friend, let me remind you, just 1 minute. Let me remind you. You just said now that the governor said they are studying the judgment. And you also said here that the matter of the status of Martin Amiewule and the rest is still in the High Court.
When
you say the matter of that status, it means you are still questioning the decision of the court.
Hold on.
You are still questioning his status.
So hold on.
That is what you are saying.
I'm holding the table now. I wanted you to come up with that point so that we can make things clear. We are talking to Nigerians,
yes.
over 200 million Nigerians,
yes.
and the other people abroad who are watching us. That Supreme Court has affirmed Martin Samuel Hule and his co-travelers as members.
Co-travelers.
Hold on.
You can't be using that language.
No, hold on now. Hold on. You don't lend me a word. Now hold on.
Acceptable
hold
now.
on. I said that the Supreme Court has affirmed them. Are you getting me? I have rights to address a governor as Mr. without putting excellence.
You can't use co-travelers.
No, why I said his colleagues. His colleagues.
It's denigration. It's denigration of the authority they wield.
Okay.
You can't do that.
If we
you can't call them co-travelers.
If we may say Martin Samuel Hule and his friends or his colleagues.
And 26 other lawmakers.
Hold on.
That's the right word.
You don't give me what
you can't call them co-travelers.
I have not denigrated them
it's
at
denigrating.
All.
How are they co-travelers?
Are they not in the same group with him?
How are they co-travelers?
An elected member is a Nigerian first.
You can't call them co-travelers. That's the wrong word.
Hold on. Let's get it clear.
Don't use that word.
No,
use the appropriate
you don't
word.
Gag a man.
I'm not gagging you.
Hold on.
Use the appropriate language.
Which is appropriate now?
You
the one you like.
You can't call them
co-travelers. Listen to me. You must allow me to land.
Go ahead.
Hanging me on the air and giving judgment on me. You are infringing on my rights.
Go ahead, but don't call them
co-travelers.
Listen,
I said that Martin Samuel Hule and his friends or the rest of them in this matter, as according to the judgment of Supreme Court, are the members and speaker of Rivers State House of Assembly. That is acknowledgement. And that should be respected, please.
So what is
now,
allow me. He has the floor, please. Go ahead, Nze. Go ahead.
Coming to the issue, the statement of the Rivers State government here now, as we all heard yesterday from the commissioner, who is the mouthpiece of the government. He said that they have acknowledged the judgment, they are studying it, which is the right of every Nigerian. When you get judgment, you go through it, and it will be interpreted to you, perhaps by those who know better than you. So by the time the interpretation of this judgment is given to them, they will see the implications that is there. But however, the issue of defection that occurred, hold on. The issue of defection that happened on 11th day of December is still pending in the Rivers High Court.
Was not touched.
So that now there was a question you asked that I began to answer from this point before we now get into this other altercation. You said that the Federal High Court sitting in Rivers State had to adjourn this case to 30th of April, waiting for reaction or the judgment of Supreme Court. Now I told you, based on that, when this matter was brought before us here, we applauded that judge. Because if other judges had told the same part that this judge is doing now, most of the, if I would call it, different court judgments and court orders wouldn't have been flying here and there. But he has said, which everybody who wants to live in a sane society will agree with him. Let Supreme Court give their judgment. And Supreme Court has given judgment. Now, this other case that is before him, or before his court, the lawyers to Amwehule and the lawyers to Okojombo will interpret their stand on it. And it is based on the argument that he will give his judgment. So he will not give a blind judgment where the parties have not come to defend themselves. He will allow the parties to come. I think probably by 30th of April, the parties will come together and they will begin to argue this matter again. It is possible that after arguing this matter, he will see reasons to give judgment for or against. And whichever way it comes, we still have the room there to continue.
You know what? From this explanation, what I see from what you have said so far is that there might be a possible of further impunity in Rivers State, in the sense that the Supreme Court has mandated the governor exercise because the budget has extended its tenure, like the budget has been expended. But then Supreme Court appears not to consider the time, and is saying that the governor should represent the and we have not even looked at the fact that the 2025 budget has been presented to even a lesser number. Recall that Supreme Court said that the presentation of 2024 budget to Edison here is that house that the governor legislated the budget of a state with only 12.5%. Now, if that number has further reduced to 3, it's safe to say that the governor, legislated
to a lesser percentage.
9% of the entirety of Rivers State population. Now, that is another conundrum, because everybody is focused on 2024 and nobody is talking about 2025 budget that probably Martin Samehule is going to consider as gross misconduct, considering that there has been judgments, telling the governor to present that budget prior to the Supreme Court judgment. When you're looking at that, and then you're explaining that the statement of the Commissioner for Information saying that the issue of defection is still before a high court, means that the government of Rivers State possibly may try not to present that budget or obey Supreme Court judgment on the ground that there is a matter before the Federal High Court.
The truth is this. We analyze issues. We bear our opinions. But that does not mean that that is exactly what will likely happen. The Commissioner of Information has not said they will not obey the Supreme Court.
He said that the Supreme Court, the issue of defection is not before the Supreme Court, but before, if that is the position of Rivers State government.
I believe that we have wise men surround, in fact, who are the payroll of Rivers State government, who will interpret all this and perhaps advise the governor accordingly.
Don't you think, to a large extent, the interpretation and the advice so far has even landed Rivers State into more conundrum than it has been? Because, if these legal luminaries, these legal bigwigs and heavyweights, have so far given advice, and the Supreme Court in its judgment has come out to accuse the governor of dictatorship and of governing in flagrant disobedience to the rule of law and to court orders and judgments as advised by these legal luminaries.
Let me say this, Loresha, before you move to the next thing. Look, there are issues. We are on national television. There are things I don't think that ethics will permit us to say. Otherwise, deep down in our hearts, there are things we see. Deep down in our hearts, there are things we claim to know. But when we discuss on a platform like this, we maintain a decorum. We maintain a level of reasoning. You see, I have been too careful from beginning. Even when Amy told me that he wore garment of purity and I wore garment of purity, for that we shall be gentle and all that. But I discovered that he lost his gentility anyway along the line. But however, however, I've been very, very careful because let me say this on air, that when this judgment dropped, the first person that hit your mind was Nze Onze.
Why did you say that?
Because when I looked at the judgment, I read through it, and after laughing, I requested for food. And while I was eating, your call came. So I wanted to be, civil by first gulping my food and now talking with you. And the first question you asked me on phone was that you wanted to check on my mental health. So I now had to resume my eating and told you that I was enjoying fisherman native soup. However, you see that all these things that are happening is just for us. If what is happening in River State can set a precedent.
Do you know that at the end of the day, everything you have said here did not answer the question that I asked you?
Do you know?
And that was, hold on, and that was with regards to you talking about the legal luminaries advising the governor on what to do.
That's
and what
why
not to do.
I told you that there are several things.
In reaction to the possibility of River State government not obeying Supreme Court judgments, premising the fact that there is a matter at the Federal High Court sitting in Port Harcourt. But since you've not answered that,
hold on. Before you move to Amy on this point, I told you there are several things we don't want to. There are several things we don't want to say.
Apparently,
on this.
Having said that, you don't wish to react to it.
Okay, yeah.
You don't wish to react.
So there is no need to. Let me keep it to myself.
There is no need to nicodemously try to maneuver, out of this. It's okay, but it's a question that I am going to ask, and now I will ask Amy. Amy, what do you make of the statements in allusion to the Commissioner for Information saying that the issue of defection is still before the Federal High Court? And my question that, will this, this statement, if you're to interpret the body language, does it mean that River State government may not obey the Supreme Court judgment pending when the High Court gives judgment?
You see, I belong to a group, and that group have a book which serves as a guideline, and that book also serves as a way to live. And in that